Mic's on. Can you hear me? Yeah, there we are. This will be the Tuesday meeting of the Legislative House Committee on Judiciary. We're actually meeting for behalf of Tillery, who has two bills today. And Senator Kennedy's not here yet, I don't believe, is he? Don't see him, so we'll bring up Senator Tillery of the 19th. You've got two bills with us. One is your Senate Bill 321. You want to come forward? We'll take your bills up. You have anybody you want to bring with you, you're welcome to invite them up.
Okay, thank you, Mr. Chairman. Nick Smith is welcome to come up if he'd like from the Attorney General's office.
Okay. Senate Bill 321, yes, sir.
And thank you, Mr. Chairman, members of the committee. Senate Bill 321 arose out of and it's heard in subcommittee yesterday. We had, I'm sorry that Jim Mooney can't be here today to speak because he is very eloquent, and the members of the subcommittee can tell you he has forgotten more about this bill than I can tell you about it. Very well versed in what he does, but just in summary, Medicaid is funded at the state level 50% Fed, 50% state at the worst possible ratio, and it actually improves from there. Georgia's is roughly 1/3 state, 2/3 feds. If we have any type of fraud and we are able to recover that fraud and have penalties associated therewith, we pay back those monies in the exact same ratio they were paid. So 2/3 to the feds, 1/3 to the state. However, if we have what is a Medicaid fraud compliant legislation, we are able to have a 10% surcharge on what we get. So in other words, instead of just getting 1/3, 33%, Georgia would get 43% in any type of recovery. So there's four things that Georgia has to do to meet the requirements of Medicaid to have that 10% surcharge. We've already met three of them. The fourth is this bill. If we pass this bill as it's laid before you now, it will make us compliant with the fourth, and we'd be able to have a 10% surcharge of sorts when we have Medicaid fraud and recoveries therewith. So and that's basically the summary of it, Mr. Chairman.
It doesn't say why. It refers to federal statutes.
Yes, sir.
Okay, so by our adopting the reference of these federal statutes, we've now somehow complied with the requirements of federal law?
Yes, sir. And I can explain that if you'd like. It's actually a perfection of the House. The Senate had in the exact dollar amounts as they are today, and today the exact dollar amounts is that you should have a civil penalty of not less than $11,181 and not more than $22,363. The reason that those numbers are not even figures is because interest rates change every year, and we would therefore be out of compliance every January.
Okay.
So what the reference to federal code was a House improvement from your subcommittee to say, senators, y'all may want to come back and address this every year, but us on the House have better things to do, and we'd rather take care of it once and for all.
And currently, Georgia's on a probation period, a grace period, and
Okay.
HHS IOG has indicated that instead of choosing to list the dollar amount, they have already indicated therefore we should match the language that the amendment gives, and other states such as Oklahoma have the same language too. It's already been approved, so that's the reason for the amendment. So
Okay.
come into compliance.
I've got a question for our legislative counsel, Mr. Talbert. Is there any problems with our making reference to federal statute as being the law for the state?
Possibly. The issue is that,
You want to take a mic over there that you're sitting there next to that one? There you go.
making the reference in and of itself is fine, but the issue is that it's going to be
Future.
law at this time.
At this time, so future changes of that law,
It's not going to have an effect.
that's what I wondered about.
Yes, sir. And
What
Mr.
should we
Chairman,
do?
I went over this with legislative counsel
did
as
you?
well, that it might be we're delegating a task that we may not be able to delegate. But I would ask that if it would be at the will of the committee to pass it as it is, because we have a letter from the feds that say the language that's written right now is the language they will accept.
Okay.
And we may end up addressing this in the future. You are very well likely correct.
Don't know if there's a way a third party has a, say, challenging this at some future date. Let's say 5 years down the road, we haven't changed the law, and now we're ready to apply these civil penalties. You can't do it because you're not really only as to what you had in the law on, let's say, May 1st, 2018, when the bill was signed.
Yes, sir. And I don't know that the dollar amount changes over those years. I agree with you that the $11,181 will probably be the minimum fine we could charge, and the max being the $22,363. However, I think the bigger dollar value for the state is that 10% add-on. So if Medicaid is going to give us that, the civil fine is probably not. It's probably
10%
minuscule
for the purpose of having handled the litigation and collection efforts,
And-
et cetera.
and for having that the four things in place that I apologize that I'm blanking on right now. I know that this is the fourth, and
But we can
and
defer
being
till you come
involved
back
in,
with that information.
yes, sir, if you need to, I understand. But yes, sir, it's for us being involved in the litigation
right.
and helping them recover that fraud.
Who on the committee wants to help out Senator Tillery?
There's a lot of people running to my defense here. I appreciate that.
All right. Anybody have any questions of the presenter on the committee? I don't see any, so fortunately pass that goal. Do we have anyone else who would like to address the committee on Senate Bill 321? We're working off LC 41-1503 ERS. I did mention that earlier. So there's no one else who'd like to address the committee. If that be the case, we'll close off further public comment, and the bill is now in the breast of the committee. Do I have the chair will entertain motions? I hear a chorus of do pass. And a second. Any discussion on the motion? No amendments, I'm sure. So we'll call the main question, which is a do pass Senate Bill 321 as presented in committee. All in favor signify by saying aye. Opposed, like sign. Motion carries. Keep your seat. This what? Who's the House sponsor going to be?
Representative Beskin.
Representative Beskin. All right. Next we have is going to be the Senate Bill 431, and that will be working off LC 297897. Senator Tillery.
Thank you again, Mr. Chairman. Senate Bill 431 comes from a court case that came down from the Georgia Supreme Court this year. It was Harris, Garden City v. Harris. You may have heard a little bit about this. I know that there was a House bill that was very much similar to this. This bill tracks the language of Representative Hanson's bill almost verbatim. The only difference is on line 9. You'll see 3 words, by any person. It was just a clarity that was offered to alleviate some of the concerns of agriculture members in the Senate to make sure this didn't also pertain to property damage.
All right. Yeah, we had this bill earlier. Do well remember it. What's going to happen as far as her bill?
I had dinner with the chairman last night, Mr. Chairman, and encouraged him that the language in hers was probably far superior to mine.
Well, have you had a conversation with her about who is going to have a surviving bill, or do we pass both of them, or
I don't.
Kinda
I know that
purpose?
her bill was signed to the Agriculture Committee in the Senate,
Oh yeah.
and there's not as many lawyers on that committee,
No,
Mr.
it's
Chairman.
not. And I'm sure they received it for a reason other than favor of that bill. Wouldn't you say?
I'm glad to be before the the House Judiciary Committee, Mr. Chairman.
All right. We've got the bill, Senator Tillery, and this is a bill that we had for our member of our committee, Ms. Hanson. And do we have any comments or questions? Yes. Ms. Beskin.
I do have one question. Thank you, Mr. Chairman and Senator Tillery. Just one question about this language, and I know I was in the subcommittee when we discussed it yesterday. And we talked about whether this person was on a date or not. And so now it says that it's going to cover injury suffered by any person on a date when the owner charges anyone to go upon that land. And I'm wondering whether we could insert the word who legally enters or goes upon the land. Because I think the case was a dad paid, but the child came in free and the child was injured. I'm thinking of a case where there's something going on that property and admission is being charged that day, but someone is injured who's not there with someone who paid, someone who might be a trespasser even, so.
Well, you say it charges admission to any person
Right.
who enters or goes on the land for recreational use thereof.
But in the case, the Harris case, it was the child of someone who had paid. The child got in for free. And everybody thought that was a terrible result. But I'm thinking of a situation where there is an event happening on property and admission is being charged on that day for that event. But someone is there, not legally, who is a trespasser, who didn't pay, who didn't come with anyone who paid.
Let
So
me
thinking
ask
of
you
that.
this, not to read out of order, but I think we want to wait and have that as a discussion on the bill when it's with the committee, as
Okay.
opposed to now.
Thank
Do
you,
you have
Mr.
any
Chairman.
questions of Mr. Tillery?
You're right. Thank you, Mr. Chairman.
All right. Anything further? Anyone, questions of the presenter? Senator, thank you. Anyone desire to speak to the committee on the matter of Senate Bill 431? If not, we will close off further public comment. The bill is now in the breast of the committee. Ms. Besk, they have due pass, all right. Any discussion on the motion? A second to the motion first. Have a second. Discussion on the motion. Ms. Beskin.
My comments are that, in state begin, whether it would be wise to insert the word legally on line 10, so that the situation that resulted in the case of the child who was there not paying admission with the parent who did pay admission would be covered, but would not expand premises liability to people who weren't legally on the property, had not come with a person who had paid, perhaps were even trespassers.
All right. Any other members have discussions about the matter? We have a motion to pass. Do we have any amendments?
Yes, Mr. Chairman.
State your amendment.
To enter the word legally on line 10 between the word who and enters.
Do we have a second to the amendment? There being none, the amendment fails for lack of a second. Do we have any other amendments? There being none, the chair will call the main question, which is a due pass recommendation of Senate Bill 431 as LC 297897 as presented to committee. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Thank you, Mr. Chairman.
Thank you too,
Mr.
Senator.
Chairman, if
Always
I could take a
pleasure.
moment before I leave, this is the last bill I'll have before you all, your chairman. I just want to tell you, you've meant a lot to me as a freshman, learning a lot, and I appreciate what
Well,
you've taught me.
I appreciate your comments. Who be carrying your bill in the floor?
Representative Hanson.
Okay. Senator Kennedy. Happy to see you, sir.
Good afternoon, Mr. Chairman. I'm happy to see you.
We're here on Senate Bill 301, and I have a LC 297816 ERS, and I believe it's a Senate substitute, is that right? CSC?
Yes, I
Senate-
believe
that's
we
correct.
have.
Got the same numbers?
I have LC 297816 ERS.
Yes, sir.
All right,
Then in parentheses,
SCS.
SCS.
Yes, sir.
Okay.
we're on the same.
All work the same one, as passed the Senate. Thank you, sir. Tell us about your proposal.
Thank you, Mr. Chairman. Good to be with you and everybody here. Today, this bill comes to you really from the Uniform Law Commission, which I know the chairman is familiar with, which is that organization in which we have various representatives of all 50 states who gather at least annually to talk about legislation that would be good to be uniform across all 50 states. I'm happy to tell you, pleased to tell you, this is their most successful proposal that has come out of the Uniform Law Commission, and I believe about 40 plus states have adopted this, and my understanding is the last few states that have not are in the process of evaluating this and hopefully adopting it now. In the form before you is SB 301, which modernizes fiduciary law for the internet age. Nearly everyone today has digital assets, such as documents, photographs, emails, social media accounts, and the like. Digital assets have real value, both monetary and sentimental, but they also present some novel privacy concerns. Access to digital assets is usually governed by a terms of service agreement rather than by property law. Those terms of service agreement are those contracts that we click the box yes when we're dealing with Google or some other service provider, and we say that we'll agree to all of their terms no matter how many pages the contract document may go on. And fiduciaries are often prevented from accessing or assessing digital assets by password protection or restrictive terms of service. So SB 301 provides legal authority for fiduciaries to manage digital assets in accordance with the user's estate plan while protecting the user's private communications from unwanted disclosures. SB 301 really addresses 4 common types of fiduciaries. Number 1, of course, would be the executors that we're all familiar with. Number 2, court-appointed guardians or conservators. Number 3, agents that are appointed under powers of attorney. And then finally, trustees who may serve in the capacity for someone else as a fiduciary. SB 301 gives Internet users the power to plan for the management and disposition of these digital assets in the same way that they can make plans to dispose of and have their property managed after their death. In cases of conflicting instructions, this Bill 301 provides a 3-tiered system of priorities. The first of the 3 being that if the company stores the digital assets on their servers, and they are under the proposed bill called the custodians of these digital assets, and they provide an online tool separate from the general terms of service, that allows the user to name another person to have access to the user's digital assets or to direct that the custodian to delete the user's digital assets. And 301 makes the user's online instructions legally enforceable. The second of the 3-tiered system would be number 2 if the custodian does not have an online planning option, or if the user declines to use the online tool that's provided to them as a customer of the service provider or the custodian. Then the user may give a legally enforceable directions for the disposition of these assets, these digital assets, by 1, a will, 2, a trust, 3, a power of attorney, or 4, a written record. The third of the 3-tier system would be that if the user has not provided any direction, then the terms of service of the user's account will determine whether a fiduciary may access the user's digital assets. If the terms of service do not address fiduciary access, then the default rules of 301 will apply. Other types of digital assets, many assets that fall under this category that we're dealing with are electronic communications, social media communications, and things like that. Other types of digital assets that are not communications but are intangible personal property. For example, an agent under a power of attorney who has authority to access a principal's business files will have access under SB 301 to any files stored in the cloud, as well as those stored in file cabinets. Similarly, an executor that is distributing funds from a deceased person's bank account will also have access to the deceased person's virtual currency account, for example, Bitcoin, that we're all familiar with. Under SB 301, fiduciaries for digital assets are subject to the same fiduciary duties that normally apply to the management of tangible assets that we're familiar with. And finally, 301 has the support of Georgia's fiduciary lawyers. The revised Uniform Fiduciary Access to Digital Assets Act is supported by leading companies that store digital assets such as Google and Facebook, and as I said, has been enacted in many, many other states. So with that, Mr. Chairman, I am present this for your consideration. I have Mr. Kyle King here to answer the hard questions.
Mr. King,
Yes, sir.
Thank you, sir.
anything you want to add to it?
Just very briefly, as Senator Kennedy indicated, this does have the support of fiduciary lawyers. It has been adopted by all of Georgia's surrounding states. and has been vetted through the normal channels. Probate court judges have reviewed it. Professor Mary Radford at Georgia
Oh,
State.
there.
I did.
Hit the right button.
That's well, and I had the privilege of appearing before Representative Kelly's subcommittee yesterday, and he indicated that was an important point. So I wanted to stress
To me it
that. I did also want to note, because Representative Hansen yesterday asked a question to which I did not know the answer, and that I wanted to be able to address her concern.
Okay.
She had asked how SB 301, if adopted, would affect or would be affected by SB 315, which again Representative Kelly was kind enough to explain to me was a snooping bill that does affect accessing someone else's computer network, and would criminalize unauthorized access. Even if you go in and don't steal anything, it's illegal, would make it illegal to go in there. Having looked at Senate Bill 315, I don't believe there's any concern, because Senate Bill 315, by its terms, only criminalizes conduct by a person who accesses a computer, in the language of the bill, with knowledge that such access is without authority. And under SB 301, in lines 310 through 318, this bill makes it clear that a fiduciary acting in their fiduciary capacity is an authorized user for wards, decedents' estates, settlors, and such like. So both of these bills, I think, would work well together. If they're both adopted in their present form, there
We're
should
missing
not
that
be an issue.
page,
I'm sorry.
page 10. I am. Everybody got page 10? Everybody's got it.
Okay. Well, I have a copy of it if you want to.
Okay.
If you want me to hand it to
We
you.
talk about that particular line, look to see where they ain't here.
Well, I apologize.
We'll get it. We'll get it. If you've got a page 10, let me have that, and I'll get it copied
Yes, sir.
for us.
Sorry about that.
While you're doing that, I'll ask something that comes to mind. I was, as you're going through the explanation behind the bill, the one thing that comes to mind is this issue about the password and this, quote, secrecy of the password. And I'm thinking specifically with not Google, Amazon. No one has ability and capable of getting into that password. How do you have access if the testator does not go through the steps you talked about, where you authorize people or have something in the will, and et cetera, but you have no known password, but all these assets may be tied up in a type of account that's guarded in that manner?
Well, ultimately, if the user himself or herself does not take advantage of the online tool to be able to designate a person, or if that person fails to leave a will, set up a trust, sign a power of attorney that authorizes someone, ultimately the default rules would allow a person so designated as a conservator, as a trustee, as an executor or administrator, to go to the probate court and seek a court order to gain access to certain information. The specific issue you're dealing with is, once someone is appointed appropriately, that individual will be able to go through the same process that you or I would if we forgot our own password, to be able to go to say Google, and tell them I've forgotten my password, receive that information, a temporary password to log in, and then that individual would be able to set a new password in their fiduciary capacity. So there's a series, as Senator Kennedy outlined very well, there's a three-tiered system, but
Okay.
ultimately a person would be able to do that.
Okay. Other questions of the presenters? There being no further questions, if there anyone else who wishes to address the committee on Senate Bill 301, please speak now or forever hold your peace. I see bankers back there, and they're just quiet as could be. We've got the page 10. Is there anything anyone wants to review here and ask the presenters regarding page 10? Or you say, what lines was it, Mr. King, that we're
It
addressing
was
with the
beginning on line 310 and continuing, I believe, through
fiduciary
318.
acting, within the scope of the fiduciary's duty shall be an authorized user of the property of the decedent.
And that's the
Protect the
language.
person, okay.
Yes, sir. I'm sorry for interrupting.
All right.
That's the language that we believe would fit in well with Senate Bill 315, which only criminalizes conduct by someone who is accessing it without authorization.
All right. Anything further from members of committees of the presenters? And there being no further public comment, we will close off further public input, and the bill is now in the breast of the committee. Do we have any motions? We have a motion to pass. Is there a second? It has been seconded. Any discussion on the motion? There being no discussion of that motion, is there any amendments proposed? No amendments proposed. We'll call the main question, which is a do pass to Senate Bill 301 as presented. All in favor signify by saying aye. Aye. Opposed, like sign. That motion carries. Senator Kennedy, glad to see you, sir.
Thank you, Mr. Chairman. Thank you and the members of the committee. And I don't know if I'll have an opportunity to present another bill to you, but if not, congratulations on a fantastic career. And thank you for your service to this body, to the state, and also on behalf of the State Bar of Georgia. You've been
Thank you.
quite a servant in that regard, too. So thank you.
Appreciate it. Who you want to have this carried by in the House?
Representative Fleming, I think.
Fleming?
Yes, sir.
All right. We will so note.
Okay. Thank you.
Thank you, too.
Thank you, ladies and gentlemen.
That was quick and down and dirty. Meeting adjourned. Everybody gets up and leave.